Good evening, everyone. We welcome each one of you to our Advocate on Record Aspirants Academy. Before we go into the topic, it is our usual practice that we recite the preamble of the Constitution of India with a sense of commitment and sentiment, because we strongly believe that preamble is our goal and preamble our soul. So I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Now, let me take you to the next topic for today. That is also very important, lecture number 43. This is with respect to paper 3, professional ethics. The question is, where I have taken it from the ethics paper. So the question is, what is the role and responsibility of media in reporting on sub-judice matters? This is most relevant topic, irrespective of the examination point of view. What is the role, and I repeat, what is the role and responsibility of media in reporting on sub-judice matters? So let us dissect this term. What is the role and responsibility? So media has got key role to play, but with certain responsibility. They have a Lakshman Rekha. Media can reach up to the Lakshman Rekha but cannot exceed Lakshman Rekha. And what is media about? Media means print media, electronic media, audio, visual. Audio means radio, visual means TV channels. What is sub-judice matters? It is pending for consideration before the court of law for authoritative pronouncement. It is not a decided matter, dear friends. It is a pending matter for consideration. So, when a media is reporting on pending matters, they should be very, very cautious. So, to approach this topic, where to go, where to approach, I want you to travel along with me. First, let us go to the preamble first. Always, preamble is our guiding light. And in the entire Constitution, one thread line which goes from the beginning till the end is rule of law. Rule of law is there. The object of entire Constitution is reflected in the preamble of the Constitution of India. So where to get this? Liberty of thought, expression. Where the media is reporting, they have the liberty to express. That is their right. So they are getting it from the preamble. Next provision that I request you to study is Article 19(1)(a) of the Constitution of India. What does it say? Let me read for you, dear friends. Article 19, protection of certain rights regarding freedom of speech, etc. Clause 1, all citizens shall have the right to freedom of speech and expression. Implicit is freedom of press. And what is the restriction? See, now they have got a freedom to express, but it is not an absolute right. It is subject to reasonable restrictions. What are those restrictions? 19.2. Nothing in subclause A of clause 1 shall affect the operation of any existing law or prevent the state from making any law insofar as such law imposes reasonable restrictions on the exercise of the right conferred by the said subclauses in the interest of sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court. For today's topic, contempt of court is very, very important. Contempt of court, defamation or incitement to an offense. So they have a freedom to express, freedom to report even what is going on, because matters are going on in the Supreme Court. The very next day we read it in the headlines that this is what happened. So they are reporting even with respect to the sub-judice matters. So to what extent they can do it, and are they overreaching, are they committing contempt? So that we need to see. So what is the next step? Contempt of Courts Act. See, I am asking you to go step by step. Therefore, it is a life lesson where you can do it in your practical experience also when you get the cases. So in the Contempt of Courts Act, what are the relevant provisions, dear friends? Always before you start, at least read the index. We are not expected to read the entire act. At least the index you can read quickly. Therefore, the relevant sections that you can read in detail. Section 4 of the Contempt of Courts Act, which deals with fair and accurate report of judicial proceeding, not contempt. This is relevant to our today's topic. Section 4 of the Contempt of Courts Act 1971, which deals with fair and accurate report of judicial proceeding, not contempt. I am reading the index, dear friends. Section 5, fair criticism of judicial act, fair criticism of judicial act, not contempt. Section 7, I am moving on to section 7. Publication of information relating to proceeding in chambers or in camera, not contempt in except certain cases. They have said even reporting of in camera proceedings is not contempt, but it amounts to contempt in certain exceptional cases. So these three sections I will be reading it for your kind consideration, dear friends. Section 4, fair and accurate report of judicial proceeding, not contempt, subject to the provisions contained in section 7. That means whatever we say it in section 4, it should be subject to the conditions what we have provided in section 7. Subject to the provisions contained in section 7, a person shall not be guilty of contempt of court for publishing what? A fair and accurate report of a judicial proceeding or any stage thereof. So press is not, media is not prohibited from reporting, but such reporting should be a fair reporting, accurate reporting of a judicial proceeding or any stage thereof. Therefore, it cannot be a trial by media, because there are several cases where the Honorable Supreme Court deprecated the practice of making comments in the sub-judice matters because they are overreaching. When, for example, there is one case, MP Lohia, let me tell you this case, this is very important. MP Lohia versus State of West Bengal and another. MP Lohia, Lohia versus State of West Bengal. It is reported in 2005, Volume 2 Supreme Court Cases, page number 686. I repeat, 2005, Volume 2 Supreme Court Cases, page number 686. So what is the case is about? Again, the husband and wife problem. Wife died and complaint was given by the relative of the deceased wife. FIR was registered under various sections: 304B, 406 punishment for criminal breach of trust, 498A read with section 34 IPC. FIR was registered. Investigation is under progress. Now husband is afraid that he can be arrested by the police officers at any point of time. So he prefers anticipatory bail before the trial court. Rejected. He comes to the High Court. Rejected. Now he comes to the Supreme Court. During the pendency of the case, the media people, print media, they have gone to the father of the deceased and asked about what has happened. And whatever he has said, they have explained it in very detailed manner in the newspaper, in the magazine. The name of the magazine is Saga, titled Doomed by Dowry. So the relevant portion I will read, dear friends. Though the Honorable Supreme Court has granted anticipatory bail in this case, the para 10 is very relevant to our topic. Having gone through the records, we find one disturbing factor. Which we feel is necessary to comment upon in the interest of justice. See, in the interest of justice, the death of Chandini, wife's name is Chandini. The death of Chandini took place on 28 October 2003. And the complaint in this regard was registered and the investigation was in progress. The application for grant of bail was disposed of by the High Court of Calcutta on 13th February 2004. And special leave petition was pending before this court. That means it is pending for consideration. Anticipatory bail was pending for consideration before the Supreme Court of India. Even then, an article has appeared in a magazine called Saga, titled Doomed by Dowry, written by one so and so, based on her interview of the family of the deceased, giving version of the tragedy and extensively quoting the father of the deceased as to his version of the case. The facts narrated therein are all materials that may be used in the forthcoming trial in this case, and we have no hesitation that these types of articles appearing in the media would certainly interfere with the administration of justice. So this is where the Lakshman Rekha drawn by the Honorable Supreme Court. So when you make those articles published in the media would certainly interfere with the administration of justice, we deprecate, we discourage, we deprecate the practice and caution the publisher, editor and the journalist who were responsible for the said article against indulging in such trial by media. See the harsh words used by the Honorable Supreme Court. It is nothing but a trial by media when the issue is in sub judice. However, to prevent any further issue being raised in this regard, we treat this matter as closed and hope that the others concerned in journalism would take note of this displeasure expressed by us for not interfering with the administration of justice. For interfering with the administration of justice. For the reasons stated above, these appeals succeed and the same are allowed. So from this what we study, dear friends, they have a right, media has got a right to have a fair criticism, accurate reporting of the pending matters, but certainly when you are dealing extensively about what was the comment of the complainant, the father of the deceased, definitely if it is read by the judges, it is going to bias their mind to some extent. So therefore it would amount to conducting trial by the media, and this affects the administration of justice. Therefore they have said you should not do all this. We deprecate this practice and we hope that our displeasure expressed in this judgment will prevent many other media to come out with such a episode or such a reporting. So this is one judgment, dear friends. Now moving on to the next aspect of the Contempt of Courts Act itself. Section 5 of the Contempt of Court Acts deals with fair criticism. There is a concept called fair criticism of judicial act, not contempt. So what is the definition of fair criticism? It depends upon the facts of each case. You criticize the judgment, whether is it fair or unfair. It will be left to the wisdom of the court. Generally the test is, if it is of constructive nature, if it is for the growth of the institution is concerned, then it is a fair criticism. If you damage the institution by your criticism, or if you are going to shake the confidence of the public in the institution, then it will definitely amount to the contempt. So fair criticism of judicial act, not contempt. A person shall not be guilty of contempt of court for publishing any fair comment on the merits of any case which has been heard and finally decided. I can give you one illustration, dear friends. Very recent judgment by the Honorable Supreme Court with respect to the governor's power, withholding the bills. The state of Tamil Nadu versus the governor of state of Tamil Nadu. The Honorable Supreme Court has held categorically and fixed the time frame also for the governor as well as for the president, when to give the assent, within what is the time frame. And yesterday in Hindu newspaper editorial, there was a column written by one of the Supreme Court lawyers commenting about the judgment. Though the advocate was supporting the entire judgment, at the last he has given a criticism on the judgment. What are those criticisms? Is it a fair criticism or unfair criticism? Let us see. The first criticism made by that concerned advocate was, though it is of very, very important judgment, but it is running to 414 pages, 414 pages. The lordships could have reduced the page numbers. He compares with UK judgment, very important judgment, Brexit versus the Prime Minister case, where it was running to only 24 or 28 pages. Here 414, and he compares with 24 pages of important judgment. So he makes a fair criticism by saying that it should not be a lengthy judgment, number one. The second criticism the learned advocate made was, when this matter was heard by the honorable judges, there are similar cases were also pending by state of Kerala, by other states. Why those matters were not tagged together and heard together and pass a common judgment? Now the entire judgment is delivered. Now state of Kerala is urging before the honorable court, we are also sailing in the same boat, hear us. So that should not happen. The honorable Supreme Court registry should have made that pending matters having the common interest should have been tagged together, heard together, and could have been a common judgment. So these are the two criticisms made by learned advocate. So if we look at it, whether is it a fair criticism or unfair criticism? Is this for growth of the institution or destruction of the institution? When we ask ourselves, we can say that it is a fair criticism because they never used any scandalous language. With utmost respect, the advocate has said, instead of 414, why not? And instead of tagging, this is growth. For the growth of the institution, he has made fair criticism. It will not amount to contempt. Now, section 5, fair criticism of judicial act, not contempt. Section 7, which deals with publication of information relating to proceeding in chambers or in camera, not contempt except in certain cases. What are those cases? Notwithstanding anything contained in this act, a person shall not be guilty of contempt of court for publishing a fair and accurate report of a judicial proceeding before any court, sitting in chambers or in camera, except in the following cases. So if it is an in-camera proceedings also, they can publish, but except in certain cases. What are those exceptional cases? Where the publication is contrary to the provisions of any enactment for the timing in force. For example, when there is a divorce case, even in the nomenclature, when you go to the case status, you cannot read the name of the parties. They have put only XXX like that. Why? Confidentiality. Nobody should understand who are all the parties. When there is a victim of sexual violence, we do not disclose the identity of the victim. We say X or ABC or something to protect her privacy. And it should not be disclosed. It is an offense punishable. So it is prohibited. When it is specifically prohibited by the law, then it cannot be published. Where the court, on grounds of public policy or in exercise of any power vested in it, expressly prohibits the publication. Court, on grounds of public policy or in exercise of any power vested in it, expressly prohibits the publication of all information relating to the proceeding of or of information of the description which is published. See, the courts may say this cannot be published. In its wisdom, they can say so. See, where the courts sit in chambers or in camera for reasons connected with public order or the security of the state, the publication of information relating to those proceedings is contempt. D, where the information relates to secret process, discovery or invention which is an issue in the proceedings. 2. Section 7, subsection 2. Without prejudice to the provisions contained in subsection 1, a person shall not be guilty of contempt of court for publishing the text or a fair and accurate summary of the whole, irrespective of the exceptions. But if he is going to publish, see, without prejudice to the provisions contained in subsection 1, a person shall not be guilty of contempt of court for publishing the text or a fair and accurate summary of the whole or any part of an order made by a court sitting in chambers or in camera, unless the court, this is very important dear friends, unless the court has expressly prohibited the publication thereof on grounds of public policy or for reasons connected with public order or the security of the state, or on the ground that it contains information relating to a secret process, discovery or invention, or in exercise of any power vested on it. So these are the certain exceptions where there cannot be any reporting. In addition to that, dear friends, we have got a 24/7 channel and breaking news, always it is there going on. For example, when a person who is accused of something, accused of murder, say, for example, in this case, dowry death, when photo of the accused is put up and it is telecasted, and then there is an investigation going on, police have arrested him, everything was going on, and ultimately if he is acquitted, say that he is innocent, already the damage has caused, and even the judges, even the public might have a bias towards him after watching repeatedly. Subconsciously it will get registered. So right to freedom of speech and expression 19(1)(a) is on one side. Where is the right to fair trial? When there is a trial by media, then it creates a big question mark with respect to right to fair trial, which is Article 21, which is implicit in Article 21, right to fair trial. Right to reputation is also a fundamental right, is implicit in Article 21. So therefore our media is considered to be the fourth pillar of democracy. And generally the Honorable Supreme Court in its wisdom, at times they have said in many of the judgments, we don't want to regulate the media by giving certain guidelines. We want them to regulate themselves. There must be an in-house procedures, rules for themselves, therefore they can regulate themselves. So journalism, when they are doing it with the utmost responsibility, with the utmost sincerity, it is good. Otherwise, the media at times they are accountable for their unfair criticism or reporting which is not there. So definitely they can be punished for contempt also. That is what Contempt of Courts Act says. So the balance is 19(1)(a) is there, but you should not cross the Lakshman Rekha, which may encroach or which may violate their fair trial as well as their reputation also. The Lakshman Rekha is Article 21. Right? Article 19(1)(a) can say anything, but stop where Article 21 is there. So this is the Lakshman Rekha, dear friends. We hope that the Honorable Court is the competent authority to make a pronouncement on a particular case, and it can be a fair reporting, accurate reporting, but it cannot be exceeding that. That means it would amount to contempt. So this is what the role and responsibility of media in sub-judice matters, dear friends. So thank you so much, dear friends, for your patience hearing. I am deeply grateful. Now exams are coming also, so we will prepare accordingly. Now 2020 match we need to play instead of 50-50 match or trial match. So we will do that. So anything to be changed or how to write the answers, how to go ahead, if most of our aspirants are writing this year also. So if anybody wants to focus on particular topic, we'll do that also. Thank you so much. Please join us for a group photo.